us to order.
And let the record show all council members are present. The first item is a public hearing to consider an appeal that was filed with the City of San Clemente, appealing the decision rendered in an administrative hearing of a city-initiated short-term lodging unit operating license revocation hearing for the property located at 2813 La Ventana.
Mayor Schwartz, I've helped staff bring this forward, so Christina Talley of Talley & Talley is going to sub in
Okay.
for me to advise the council.
Okay. And were we going to have staff present first, or is it just going to listen to the appeal first? What's the normal order of this?
To our legal counsel. Which one, staff report first, or?
Oh, yes, Mr. Mayor and members of council, it would be appropriate to get the staff report first and then open your public
Okay.
hearing.
Madam?
Good afternoon, Mayor, members of the City Council. My name is Adam Atamian. I am the Code Compliance Manager for the city. Today I will be presenting staff's position and recommendation as it relates to the de novo hearing on the appeal of the September 27th, 2018 administrative decision revoking the short-term lodging unit, or STLU, operating license 314901 at 2813 La Ventana. With staff today, I have Valerie Escalante-Troche. She is with the City Prosecutor's Office of Silver and Wright, and our Senior Code Compliance Officer, Beverly Thompson, as well. All right. So, the subject today is essentially whether the City Council will affirm the decision of the hearing officer in a previous revocation hearing of the STLU operating license, and further to decide if the STLU operating license is to be revoked based on the presence of the violations found by staff at the STLU, for which citations were issued. City code enforcement staff investigated the subject STLU after receiving a complaint regarding the conditions of the STLU. We engaged in code compliance actions and efforts to obtain the owner and operator's voluntary compliance. This has been going on for quite some time, the violations, some of which still remain today. I will go over those in greater detail a little bit later. The violations of law discovered by the city triggered a revocation hearing, and at which the hearing officer determined that the license issued to the property owners, Peter Schickley and Edith Radnati, should be revoked. As staff will present at this hearing, as we did at the previous hearing, we will provide information and materials that conclusively show the need to revoke the permit based on conclusively found violations that existed and, as I said, continue to exist. These violations relate specifically to the owners and operators, the operators being the Seabreeze Vacation Rental Management Company. Renting and maintaining the subject STLU with significant illegal construction in the home. The specific illegal construction related to the subdivision of what was identified as a hobby room into a separate sleeping area. So that involves the construction of a wall with a door, and then the provision of sleeping quarters within that room. That room did not have any natural ventilation. It did not have egress windows required for things like fire exiting. So that's one. That That violation still remains today, and I will discuss that in a little greater detail as well. The subject STLU, the illegally modified hobby room, is in and of itself a violation of the STLU operating license. So one of the conditions is that as all properties are required to comply with the building code, so are STLUs, but it's also a violation of their operating license if they're not in compliance with building codes. At bare minimum, all properties should be compliant. STLUs, though, are providing a service to the public that doesn't have the time to, check out their living situations ahead of time. So it is most important that that occur at STLUs. In this case, it didn't. That is in and of itself another violation. The owners and operators created or allowed these conditions to be maintained despite information provided by the city about the existence of violations. The time that we have been dealing with this is approximately 13 months. There are still violations that exist today, and the response from management to address these concerns has not been timely, and nor has it been complete. The owners and operators rented out the subject STLU, also with an occupancy that exceeded what was allowed by the STLU operating license, and which they agreed to when they were provided that license. This was understood because they were also advertising that the occupancy was much higher than what they had been provided in the license. As part of the code enforcement activities to gain compliance, we requested an inspection based on the requirements of the STLU operating license, and it took an exceptionally long time to get an interior inspection of the property, and I will go through that as well. So they failed to give timely access to inspect for city staff to ensure the public's health and safety. All of the documents that are provided in the staff report are true and correct copies of the documents that were provided previously for the revocation hearing. They are now incorporated as well here. For ease of access, the attachments list includes kind of a table of contents to help you jump around, and I will be referencing some of the attachments in a bit. So, with that, starting with the main facts of the violations, the citations were issued over a couple months. There was one issued in February, in March, and then April. These citations are not at issue. They are deemed conclusively to show the existence of violations, and that is shown because they were not appealed, and they were all paid by the owners. So the citations themselves are not at issue. They are determined to be conclusive and substantiated. The attachments 22 and 23 provide true and correct copies of the evidence substantiating that the owner did not challenge the citations, and they paid the fines accompanying the citations. As far as the violations themselves, starting with the most important are the building and site-related violations, specifically referring to the unpermitted construction and the uninhabitability of a room advertised and rented for sleeping purposes. The attachment 21 provides a true and correct copy of the city's photos from its February 21st, 2018 inspections, along with attachment 18 for plans and permit records denoting what the property should look like. The violations to identify the building the complaint related to the building violations led staff to find a number of other violations at the property that are more management related. So there was an unpermitted increase in the occupancy allowed at the site, and there was also failure to provide timely access. As noted before, we had received a complaint. Now, this complaint was submitted by one of their customers. This was somebody who rented the property in December of 2017 and then contacted staff about the issues. Staff attempted to investigate this, and it wasn't until February 21st, 2018, that we were able to actually gain access to the property. The STLU operating license requires timely access to be provided to city staff to inspect. In fact, it requires a 24-hour emergency contact with a 30-minute response on site if necessary. The egregiousness of uninhabitable areas of a property being rented is within the scope of an emergency response necessary. Now, timely, access may not be half an hour, but it's definitely not 2 months. That's an exceptionally long period of time to wait for access to inspect allegations of violations, especially those that turned out to be true. So city staff has spent a bit of time, and that's a non-insignificant amount of time, addressing these violations. Attachment 19 shows a true and correct copy of the city's log of efforts to try to schedule an inspection. As noted before, this took 2 months. In addition to that, there's ongoing noncompliance. The existing room remains uninhabitable. The existing construction of the wall, there have been no permits pulled to remove the construction of the wall. I will say there was a note in the agenda report about the current status of the permits. There has been one permit that has been applied for to install a window in that room. That permit has not been issued, nor does the city have any evidence of any work being done to actually legalize the entire room. Furthermore, just adding a window doesn't legalize that room as a sleeping quarters. So to date, the violation still remains. The maintenance of the illegally constructed and uninhabitable room is, as I noted before, the main, or I should say the largest and most significant violation. And it's that way for a few things. The first is it's a serious threat to the health and safety of the inhabitants. But also, it on its own is enough to trigger the revocation hearing. Chapter 324067 of the Municipal Code discusses the revocation hearing process, and it describes a few scenarios where a revocation is triggered. One of those is a single violation that is conclusively found to exist that relates to a serious threat of safety to the public. The renting of an uninhabitable room definitely meets that threshold. In terms of commercial lodging, there's really no more egregious violation than providing uninhabitable lodging. And then, as I noted multiple times, all of that violation still remains today. In addition to that single serious threat, there are other violations that demonstrate poor management and oversight of the property, the non-adherence to the agreed upon conditions of the STLU operating license and the requirements of operations, as well as the need for significant staff time to address these issues. One of the other scenarios in Chapter 324067 that triggers a revocation hearing is the presence of 3 violations conclusively found to have existed. So in both scenarios to trigger a revocation hearing, this property has met that. And so So those are the main arguments for staff's position of revocation and against modification. Now, there was a settlement agreement that was brought up in the the revocation hearing. Staff's position is that it does not apply here at all. If there are any questions on that, I would defer to our legal counsel, Valerie Escalante-Troche. So with that, I will leave it at staff's recommendation is that City Council affirm the hearing decision, revoke the STLU operating license 314901 as reversing, revising, or modifying the decision is just simply not in the community's best interest. There's no evidence that staff can find that any of any modifications or reversing the permit will lead to better operations or compliance in the future. So that concludes staff's presentation. I'm available for any questions along with our legal counsel. I apologize. Can I have our legal counsel conclude my presentation with a short little bit?
Go ahead.
Thank you very much, Adam, Mr. Atemian. Thank you very much for your time, Mr. Mayor and council members. I will keep this very brief. As I was introduced, my name is Valerie Escalante-Troche, and I'm legal counsel on behalf of the code staff here today. I will not get into any of the factual information. Mr. Atemian did an excellent job outlining for you the consistent violations at issue with the subject STLU. As he noted, these are ongoing violations that at minimum, from the city's knowledge, have been ongoing for about 13 months. The city issued 3 citations that never resulted in any compliance. The big issue, before the council today is whether those violations and the kind of management and issues that the city has had with respect to the management of the property and trying to get it into compliance, whether that merits the affirming of the revocation decision. It is our position it does merit that. So today the focus for the council is to not consider the underlying violations. Those were conclusively found. They were never appealed. All fines were paid. That is conclusive evidence that the violations did in fact occur. And as presented here today, violations do continue. The illegal construction is still present. That property is still a danger to the community. You will likely hear, and you may have seen in some submissions by counsel for the owners and operators, that they're no longer currently renting it out. That is not dispositive on the issue, because simply a property in the city must be safe. Even if they don't have anyone currently living in there, an issue could still be triggered. There might be a water leak. There may be a fire that comes up, and first responders may need to enter the property. But because it's so dangerous with illegal construction, with no means of ingress or egress, that poses a concern. As to the settlement agreement arguments, I will be happy to address those after counsel for the owner and operator makes his positions. I also think that I will briefly address it, but BBK did advise on the settlement agreement that was here in front of the council that the council approved a few years back, and so he may also be the most appropriate person to address any specific questions. It is our position is completely outside of the scope of this hearing. It does not apply whatsoever to the violations at issue, and we can address that if and when the time does arise. And I'll leave it at that. Thank you very much for your time.
Again, anything from the council? No? No questions? All right, we'll go ahead and proceed.
Open the public hearing.
So I'll go ahead and open the public hearing. We have a card from Joe Janis.
Maybe the applicant first.
Why don't we hear the applicant first? Yeah.
Well, first of all, I appreciate the council taking the time for this de novo appellate review. My name is Brad Grabsky. I represent the owner and operator, that's Seabreeze Management, and Peter Sheekley. For sake of ease, I'm going to reference both parties collectively as Seabreeze through my presentation. As a housekeeping item, and since we are here on de novo review, I want to make sure that the city received, rather the council received, our January 14th submission letter. It's important for two reasons. One is, in reviewing the staff report, I didn't see any prior submissions that we made. We had two letters that were submitted before the hearing. One was dated August 29th, 2018. The other was dated September 14th, 2018. Since we are on de novo review, I want to make sure the record's complete and full. And I have another copy if that's sufficient.
See it? Is it in the packet? Was it part of the packet or it came yesterday? I have not seen anything yesterday.
I'll help clarify. I believe that you sent an email
I
to.
did. Per direction from city staff, I sent an email to the clerk.
I did not receive that.
You did not. Okay. Well, CC, I carbon copied council on this. This is our January 14th, right? Our January 14th, 2019 letter, which attaches as exhibits both the August 29th letter and the September 14th letter. Madam Clerk.
Thank you. And I don't receive it either. Council says they did not get it either.
Okay. Well, I only sent it directly to you. So, in any event,
Make copies.
yeah. I asked that that be included in the record. I also asked that the record that was submitted to the city council in general be updated and amended so that those two letters are actually where they should be in chronological order. Again, we're doing
They should be notated that we actually received them at the time of the hearing.
And would you care for me to wait for copies or just proceed? Okay. Some prefatory remarks. The La Ventana properties operate as a legal and fully permitted short-term rental since June 2016. It's paid all of its taxes since June 2016. It had no citations or incidents before December of 2017. We're here today as staff presented based on one incident that occurred in December 11th, 2017, where there was a rental that exceeded the maximum cap on the permit. Seabreeze took immediate and corrective action on that. They did so without having prompting from the city. They did so without having a notice of correction issued against them. The immediate corrective action effectively rendered that room drywall and concrete, as noted on Exhibit 21 the city presented. That photograph was taken on February 21st, 2018. The room is obviously level to, again, drywall and concrete. There's no way that anybody could use that room as a bedroom. And that was the purpose and intent behind doing that. Two other citations were issued, one on March 18th, 2018, and one on April 2nd, 2018. Both those citations are derivative of the December 17th issue. They are related exclusively to a kink in advertising. They're not related to any actual rental that exceeded the maximum capacity, no complaints that any rental exceeded the maximum capacity. It's based exclusively on advertising. Seabreeze tried to correct that as well. There were some technological issues, some back-end issues with some back-end software, rather. At the end of the day, advertising in and of itself is not a violation of the municipal code, and that's not what the citations were issued for either. Fast forward to April 17th, 2018, the city and the San Clemente Vacation Alliance entered into a settlement agreement with some existing litigation. That's important for two reasons, the first of which is the settlement agreement included an amortization list where 19 properties would be permitted to continue to operate as short-term rentals. The La Ventana property happened to be the very first property on that list. It's also important to note that inside of the settlement agreement, the amortization language sets forth prospective rather than retrospective compliance with the municipal code. In other words, it says these properties permits shall issue to these properties subject to operation consistent with the municipal code. It doesn't say subject to past compliance with the municipal code, etc. The second important point from the settlement agreement is that it contains a general release. And the general release includes all issues arising out of, or all issues arising out of or contemporaneous with the project, which is defined in the agreement as Ordinance 1622, 1623, and 1624. Notably, Ordinance 1622 effectively creates the same municipal codes on which the last two citations were issued. And to be specific, that's Section 3.224.067, 3.24.220, and 17.28.292. And just so I'm in full transparency, 3.24.22 actually did exist before Ordinance number 1622, but it was different. It was completely rewritten by that ordinance. So you have the settlement agreement, which expressly includes the La Ventana property. You have the settlement agreement, which was agreed to after the three citations. You have the settlement agreement, which includes a general release, which based on its express terms would include at least two of those citations. And also, the general release also includes the three strikes and you're out revocation process, which we're here before the council today. So the long and short of it is the settlement agreement should allow and does allow the La Ventana property to continue to operate. And I know I'm actually giving you a lot of information that you don't have the benefit of seeing in my letter, which kind of outlines this specifically. But I'll note that it does. I'll note that I try to lay it out in a fairly digestible fashion. But the long and short of it is our December 19th letter and prior letters lay this out, lay out the inclusion of the La Ventana property on amortization agreement, the specific language in the amortization, specific language that authorizes the amortization that is prospective rather than retrospective relative to code compliance. And then the general release, which, as I've indicated and set forth in our letter or tried to, includes the very code citations that we're talking about here today. The long and short of it is the council has discretion today to reinstate the permit. You have discretion under Section 3.24067. The council has a legal basis to reinstate the permit as put forth in our letter and as I've very briefly summarized here today. And as a practical matter, and as a matter of fairness, you have a party, constituents, negotiating a settlement agreement regarding the inclusion of the La Ventana property, arguably at the same time that city staff is plotting to revoke the permit the minute the settlement agreement, the ink in the settlement agreement is dried. As a legal matter, I think that violates the implied covenant of good faith and fair dealing. As a practical matter, I don't think it's fair. I think it violates notions of fairness, fair play. I think the city has a reputation for being a good entity to do business with and a good jurisdiction to do business in. I don't think this is one issue that's worth jeopardizing that reputation for. It was negotiated in good faith at arm's length. The city never informed Seabreeze or the owners that they intended to revoke the permit. And at the end of the day, reinstatement of the permit's the right thing to do. It's the fair thing to do. And the reality of it is, and as a practical matter, if Seabreeze is such a bad actor, they'll be right back here before you. And you can revoke the permit then, and then you won't have the issue of the settlement agreement hanging over you, and you'll hopefully avoid litigation over the settlement agreement and the interpretation of it. And with that, I'm happy to answer any questions. I apologize. It's unfortunate that you don't have the benefit of my letter, but
Yeah, I have
Go
one
ahead.
question for you. You mentioned early on, before you start talking about the settlement agreement, that they
Yes.
did not indeed violate the occupancy load. It was just a error in advertising, but I have here on attachment 15, it states, and it's certified from Mark and Kathy Bohander, that my family member rented this location November 25. We have 14, including one newborn family member staying at this location.
Right.
So were you not privy to this email, or are you just saying
No,
it does
no,
not
I'm-
exist, or that it's factually inaccurate?
No, I'm privy to it, and I'm not actually in a position to say whether it's factually inaccurate or accurate. What I am saying is, after December 11th, 2017, I'm talking about the second two citations, dealing with March 28th.
Give me that date again.
Sure.
December what?
So you have the Bolander Declaration deals with the December 11th, 2017 rental, right? And after that point, you have Seabreeze taking affirmative action, ripping out that entire room, bringing it back down to concrete and drywall. After that, the city issued two other citations.
Can I speak to the Bolander? On the agreement with the Bolanders, they told us 12 people would be in.
I'm sorry, before you can speak, you need to identify yourself.
I'm sorry,
on record.
Jeff Boston with Seabreeze. On the Bolander reservation, they, under their questionnaire of how many people would you be having in the house, it was 12. I know they told the city later they actually had 14, but that's not what their reservation was for. Just wanted to clarify that.
And just to clarify my remarks, my comments refer to the March 28th, 2018 citation, the subsequent April 2nd, 2018 citation, the two latter citations that dealt exclusively with advertising. The concept was that
Okay, I just need clarification, though. So you are verifying that 14 people stayed, or you're not verifying? What's your position on that?
I don't have a position. I wasn't there. So I'm relying on the same information you are.
But I just need clarification, because you alleged in your statement that you said the violation of the occupancy was never violated. So I just need to clarify that you're saying it was never violated, or that it was violated.
No,
Or you're
I-
not taking position on it. And I
I'm
can just
not-
redact
yeah.
that from your comments earlier, because
No,
you were very clear when you said
No,
we never went past the 12 people. So
No, I didn't mean to say that. And if I did, I was an error. No.
got it. Thank you.
I'm referring to the March 28th, 2018 and April 2nd, 2018 citations. And my comments there, just so we're all clear, and if I was unclear, I want to clarify it, that relates to advertising. The idea was you're actually having rentals in excess of the occupancy just because there's a glitch in your advertising. And I'm informed that other cities will simply call you and say, hey, your advertising is not in compliance with your permit. Take care of that. And they'll say, well, thank you.
Okay, my next question is then, when you started talking about the settlement agreement,
Yes.
it seemed to me as though you're talking about the life and safety code violation in terms of the unpermitted bedroom, as though it's, well, we did it that one time and it's fixed now, so we should never have been fined for it in the first place. Is that the logic that you're following? Because if I get a ticket for speeding, I said, well, I haven't sped since then, so we should delete that ticket. That seems to be the logic line you're following. And explain to me how that's not the logic line you're following.
Sure. No, that's not the logic line I'm following. No, what I'm saying is, as an initial matter, we took affirmative action. My clients took affirmative action. They took affirmative action without any requirement to do so from the city. The settlement agreement is a different analysis completely. It's not whether it happened or whether it didn't happen. It's what is and what is not included under the language. So,
Dan?
Sturts, thank you. What was the immediate corrective action that Seabreeze, your client, took?
yeah. I think a picture's worth 1,000 words. If you look at exhibit number 21, the photographs, I'm informed that that happened right away. In other words, that the rooms were brought down to drywall and concrete to ward off anybody in the future using it as, thinking that it should be used as a bedroom, habitable space, et cetera.
Okay, well, I guess, I'm sorry. My question, though, is there was no building permit that was applied for that wall, correct?
I don't know the answer to that. My understanding is that it is permitted. That's my understanding from the owner.
I'll follow up on that then.
Okay, fair enough.
On the settlement agreement issue,
Yes.
is there any provision in the settlement agreement that exempts Seabreeze or the property owner from complying with the municipal code?
No.
Okay.
No.
And then I guess,
Let me just,
Sure.
I mean, the nuance, right?
sure.
No, it's prospective in nature, right? So at the time the settlement agreement was negotiated, Seabreeze La Ventana is being included on the amortization list. There's other properties being excluded from the amortization list for prior bad conduct.
Okay.
All right, so just bear with me here. The language says, the language is prospective in nature. In other words, the permit shall be issued provided that the property is operating, actually, let's say is operated consistent with the municipal code. Prospective in nature rather than retrospective, not is and has always operated consistent with the municipal code, or even is operating,
Okay.
which is
and
a
then
different statement too.
You talked about the mutual release. So I guess, is it your argument that the release, to the effect that there was one, released any prior violations of the municipal code? Is that effectively what you're arguing?
Not all violations of the municipal code. Only those violations of the municipal code that could track back to ordinance 1622, which is defined in the settlement agreement as the project. So the settlement agreement arises out of a lawsuit that I think Scott Smith can probably speak to as well, out of a CEQA challenge. The challenge was that the city violated CEQA by saying that the ordinance was exempt from CEQA review. The challenge effectively was that the ordinance was invalid as a matter of law until it actually complies with CEQA review. The argument is that, not the argument, the language is a general release as to the project, which includes 1622, which derivatively includes the parts of the municipal code that I created. It's derivative in nature. Does that answer your question? I'm happy to tease this out more.
I want to, first of all, I want to read your letter.
Yes.
So,
And I would appreciate you do that. This is
take a
de
look
novo
at that,
review.
But my general understanding, and I'm going to ask our council about this, is that even if there was a release, we as a city can't release folks from complying with the municipal code.
Yeah.
And I guess I'm trying to understand if that's your argument, because even if it said that, we wouldn't have the power to do that anyway.
No, the argument is prospectively, once the permit is reissued, on a going forward basis, Seabreeze and the La Ventana property is subject to the 3 strikes, you're out scenario. And as it relates to the inclusion, hopefully I've been clear as to the inclusion on the amortization list, the release, how those play together. And no, the property would and still be subject to the municipal code and would have to operate consistent with that. Yeah, I hope that answers that question. One other point, though, I do want to note is this property has ceased all operations as of July 2018 per a cease and desist letter from the city. So the idea that there are people renting it's not the case.
What was the date on that?
July, bear with me here. I can give you a citation of this in our briefs, too. July 16th, 2018, a letter from city staff indicated that the permit had expired that without acknowledgement to the settlement agreement, and noted that it's operating without a permit and must cease and desist all STLU operations, and as reasonably prudent people, they stopped doing so. So the permit is effectively revoked in our eyes on July 16th, 2018. And operations ceased on that day as well. But that email can be found at, if for a citation, it would be Exhibit A, Sub-Exhibit 3 to our letter. And it would be an email dated from our Stephanie Roxas, senior planner.
Kathy?
I have a couple questions as to what you said before about the violation was immediately corrected. The incident occurred, the complaint was December 11th, yet we were not granted access to that property and those pictures taken until February 21st. Is that correct?
That's my understanding about the day code on the pictures. When the incident was reported from the city to Seabreeze, I don't have that immediately available, so there might have been some lag time. We
have it in here of
Okay.
our staff talking to them.
Fair enough.
But what do you say about your client that you're representing, that they're supposed to actively manage these properties, especially if there is a health and safety code violation where people are in danger, that on December 11th there's a complaint and we can't get into the property, which they agreed that they would allow us entry to within 30 minutes if it was a safety issue.
Right.
And we didn't get into there for over 2 months.
Yeah.
So how do you say anything to that?
Yeah. I can only say two things. One is we weren't dealing with a 911 call, but I appreciate the concern relative to health and safety. The property was made available the minute there weren't renters there. That's
Then, as far as I'm concerned, it looks to me like the room was still there. We don't know until we were allowed entry in 2.5
Right.
months. I mean, there's no evidence of what you're saying, is what I'm saying. I'm looking for it.
yeah. I could ask Mr. Boston to come up and he can actually provide you with testimony on that point if that would be helpful.
So also, does your client have a local number? I'm seeing only a Newport Beach number and an office for rentals here in San Clemente. Is
Yeah.
there a local number?
Ma'am, I'd have to defer to my client, Mr. Boston, who
So that's our 24/7 number, that there's always somebody on, 4 in the morning, doesn't matter. And then every night, there's a local person that if somebody needs to go to the house, whoever takes the call at the main office would then call the local person to go out to the house. That way, no matter what city has a problem, they have one central 24/7 number to call, and then we get somebody on it locally.
Why did not anyone come for over 2.5 months to this property?
No, we did. We immediately went out to the property, and the very next day stripped that room down. Nobody stayed in that room past December, but there were renters in that house. We gave access at the first available
Why
time.
did you not allow our code enforcement in there to see that, if that's the case?
I can't speak to that. We gave access as soon as there were no renters in.
So to rephrase it, we were noticed of a violation. We told you about it. We asked for access to confirm it.
You asked for
And you
access. There was
decided-
no
And you decided,
corrections.
and it was decided to continue to rent it until all the renting were gone before you allowed the city come to inspect. So basically, for 2 months, with an outstanding violation, you continue to rent the place out. Correct?
We allowed the renters that were in to remain. Correct.
I just did that. I thought, who else did that last year?
Do you have anything?
Earlier, you spoke about how the city didn't provide intent of the revocation of the permit. The revocation of the permit, the city didn't provide ample time, you mentioned, before it revoked the permit?
He said there was no notice of any relocation.
Right, no notice, you didn't notify. You weren't notified, but yet you implied that on July 16, 2018, you took that as your intent to cease operations.
we complied with a cease and desist instruction from the code from the city. That's
But
correct.
that's the first you learned that the city intended to revoke your permit?
No.
No?
No.
Okay,
No, that would not be what I'm trying to convey.
okay.
Am I-
What
is
were
there-
you implying? Did you feel that staff didn't give you ample notice? Or do you?
What issue are we talking about? Are we talking about the July?
The
2000
revocation of the permit, when did you learn that was going to happen?
Oh, I see what you're saying. It was not learned during negotiations on the settlement agreement.
Okay.
Right, so what I'm getting at there, just so I'm clear, is while the parties were negotiating what properties to include and what properties not to include on the amortization list, at no time did the city say, hey, we can, if you really want to include that property, you can, but by the way, we're going to institute revocation proceedings. My position is that should have occurred. Thank you. Okay, all right.
Any other questions of the,
I think we should take a break until we can read these.
we have staff questions. You want to do that after we take a look at that letter? Yeah, why don't we, we're going to take a 10-minute break.
If I may make one little closing pitch before I sit down, and that is, we are on de novo review, and I just would ask the city to give that letter a fair reading with open mind, and perhaps even put yourself in the shoes of folks that are on the other side negotiating with the city.
As I said, we're going to take a 10-minute break. We're going to go through this and be back and continue the hearing.
Well, thank you.
Hearing's back in order. Let's go ahead and proceed with more of our questioning. But before we do that, I wanted to ask our attorney to give her summary of, after reviewing the letter, and what our position should be.
There's one more speaker card. So did you want that?
Well, Mr. Mayor, members of council, of course, this letter raises a significant number of issues, most of which counsel for the property owner has summarized in his oral argument. With respect to my opinion as to what the council's action should be, of course, that's a matter of the council's discretion, so I'm not in a position to render an opinion on that ultimate issue. There are, I think that the legal issue that's raised here, if there's a legal issue that's raised here, is whether or not the revocation is somehow barred by the settlement agreement. I read the settlement agreement. I was not part of the negotiating of that agreement, but I believe in reading the document on its face that it doesn't apply to this dispute. It relates to settling the claims arising from that lawsuit, and the claims arising from that lawsuit dealt with the adoption of the ordinances that are being implemented in connection with this revocation, and the compliance with CEQA in connection with the adoption of those ordinances. So it was intended to settle all claims relating to that dispute. I don't believe that a revocation of an STLU for failure to comply with the municipal code falls within the scope of those claims.
Specifically, I want to cover the fact that they had citations for violations on the property prior to the settlement of the litigation regarding the ordinances that were passed regarding short-term rentals. But I want to confirm with you that didn't reset the bar as far as their being able to start over again, and we forget about the citations.
Well, the settlement didn't even address the issue of whether or not any of the properties had existing code violations. The settlement related to claims challenging the validity of the ordinances themselves, and whether or not they were valid based upon alleged CEQA violations in connection with their adoption. And so I don't believe that there's any relationship between whether or not properties had existing violations and whether or not the claims were settled in the settlement agreement.
Thank you. Did you want to ask staff questions before we go to input?
Yeah.
Okay.
Adam, I got a couple questions for you. Have you been able to confirm or deny whether or not permits have been approved for the room addition? I know you'd mentioned that in your report, but can you just reiterate it for me?
Yes, there have been no permits issued to remediate any of the uninhabitability issues and violations that exist in the subdivided hobby room.
Okay, and to your knowledge, has the room been returned to its original condition, meaning the wall taken down and the room returned to its...
We have no evidence to say that the room has been, that the illegal construction has been reversed. Further, depending on the amount of construction done, we would want a demo permit to ensure that any new electrical or any new venting was replaced appropriately. None of those permits have been applied for or issued.
Okay. Just quick on that is, was there ever a permit issued at all for the property to build the wall? I mean, was there anything permitted at all?
No, there was not.
And my last question is for our legal counsel. Thanks, Adam. In the settlement agreement, I know what the answer is, but I just want to confirm with you. In the settlement agreement, do we have the ability to look over any safety code violations? Was that outlined at all in the settlement agreement?
That wasn't the subject of the settlement agreement, to my understanding. Again, I didn't negotiate it, and so I'm basing my opinion as to the scope of the agreement by the terms of the agreement itself. So there may be somebody here better who can address the specifics of that. I know Mr. Smith was involved, as well as Ms. Gallardo Daly, but just on the face of the settlement agreement, I don't believe that was ever addressed.
Great, thanks.
Any other questions? I think we have some. She wants to put something in. Okay.
If I may just briefly be heard, the question of the settlement agreements application did come up at the prior revocation hearing. So the city, myself, our team at Silver and Wright, as well as Best and Krieger, who was involved with the drafting of the settlement agreement, submitted papers for the hearing officer that are also in front of you that discuss the non-application of the settlement agreement. So to the extent the council and mayor have any additional questions, those can be found at attachments 6 and 7 of the staff report in front of you. That will address a lot of these questions as well. They were discussed already by ourselves and as well as Best and Krieger.
Okay. Before we get into any more discussions, why don't we bring in, we have a card on this from Joe Janis.
Hi, Council. Kathy, welcome back to Council. Nice campaign. Dan, welcome to Council. Both of you guys got some negative stuff said about you there. I'm sorry that happened to either one of you, but as far as we're concerned, our group, we think you're both pretty upstanding people. Welcome, Mr. Mayor. You're going to have a busy year. Chris, welcome back. And Laura, nice talking with you also and being open to talk with everyone. The amortization period that was set 2 years ago, our group was completely against it because over 90% of our neighborhoods don't want these things in our neighborhoods. And having lived next to one and knowing that it takes 3 to 4 years to close one down and how hard staff works and code enforcement works to get there, we know it's not an easy thing. We have been in some public hearings, one on 305 Gaviota, which Seabury was involved at, and also the one that I was involved at. And it seems like that is their job to fight for their people. But as it goes, at one of the meetings, our neighbors were called vexatious neighbors, and it wasn't their fault. And they say there's only bad actors. Well, we believe that after this amortization period started, and there are 19 different structures that were given the right to continue to operate, we think they needed to be clean 100%. And when something like this comes out, and our staff and code enforcement spend so much time doing this, that you need to follow their recommendation. I know this is above me as far as the legalese stuff about it, but we'd like you to support what staff has said. Thanks.
You should. I'd just like to make a quick comment. I thought they were both great presentations.
Excuse me, for the record.
Yes, Brad Malmuth.
Brad Malmuth.
Thank you, Steve. Thank you, Steve. Thank you, Chris. You're going to have to decide what you're going to have to decide. I thought there were two really nice presentations. But my concern is a related concern. That is why this hasn't been resolved short of having to go through this expensive, costly, and staff time, legal time. Has anybody tried to resolve this at any point in the process? Maybe we need to, as a council, figure out if staff should be directed to try to resolve some of these disputes. In other words, possibly in this case, and I'm just not throwing out what you should decide at all. But why haven't these code violations been rectified before we even got here? Why wasn't there some agreement between the two parties that they would resolve this problem? I don't know if it was negotiated or not, but I sure hope somebody talked about that before we spent all this money in the city to hire lawyers, staff time, and everything else. So I hope in the future we're not visiting these types of issues with every other STU in the city if we don't try to first work things out. Thank you so much.
Dan.
All right. I have a few more questions of staff first that probably should be answered during the public hearing if possible. So, Adam, can I ask you? Talking about the violations, the wall, that's a building code issue, am I correct, and not an STLU ordinance issue? Is that right?
Not entirely. It's a building code issue, as it would be for every single-family residence in the city. But it's also a condition of the STLU operating license that they comply with building code. And it's important, that's an important distinction, because we're talking about, as the zoning ordinance identifies very clearly, that we're talking about commercial lodging in residential neighborhoods. Most hotels and motels are required to be developed with a much higher degree of construction safety for the benefit of customers, that they're open to the public, et cetera. So we're requiring that specifically for STLUs, that as part of their operations, they must comply with the building code as it relates to their license, beyond just the fact that they own a property and construction must comply with the building code anyways.
Sure, and so I guess the point that I was trying to drive at is that's a requirement separate and apart from simply their permit to operate, is that they have to also comply, because it's a dwelling, with the building code.
Absolutely, yes.
So whether those ordinances were in effect or not, does it have any bearing upon whether they had to comply with the building code?
That is correct. They do
Yes
have
or
to
no?
comply.
They do have
Yes.
to comply. Yeah. Okay, so on that issue, were there, besides the wall, were there any other electrical, plumbing, any other types of building code issues or additions that have been made to that property that weren't permitted?
Staff has not had a chance to review the entire site fully. We were provided one inspection, which took 2 months to get. At that time, we were not able to do a full inspection of all of the potential unpermitted construction. We would see that in the building permit process, where an applicant would submit a plan that shows what they want to do. Staff would review it as it goes through the process. When we're looking at after the fact walls, we're not opening the walls up. We're not looking inside. There's no application, so there's no real process at that time for us to investigate the extent of the violations.
Well, was that not allowed by the property owner, or we just didn't have the chance? I mean, were there fire alarms? Every dwelling room, as my understanding, has to have a fire alarm.
Yeah, I'm not sure on those exact specifications. Beverly Thompson was the staff that actually inspected. I'll let her answer those.
Great, thank you.
Good afternoon, Council and Mayor. We did make a short site inspection. We were granted access to the one room in question at the time by a representative from Seabreeze that showed up. And
Just the one room?
Yes, just the one room. And we were able to see the wall, and there were 2 electrical outlets, but like Adam's referred, we can't see everything behind the wall. We don't know how all that was put together, all the studs, all the drywall, the nailing. We can't see everything from that side.
Sure, and so when you refer to the wall, we're talking about the wall that was added.
The
So
devising wall
there were
between
electrical outlets on that wall.
Correct.
Okay.
And there was a hobby room that was almost like a U-shaped, and there was a wall put in between. And on their submitted STLU plan, they showed those as
Were there
rooms.
permits for the electrical outlets? Are permits required for electrical outlets?
Yes.
Do you know if there was a fire alarm?
That I couldn't tell you. We were let in very quick.
Or a
and
smoke detector? Is what
we were
I'm-
let in very quick, and also we were looking at the grinder pump. There was a sewage grinder pump that was in there.
Is that permitted?
We found permits. We found final permits for all the plumbing and all the HVAC. I've talked to the building inspector, plan check engineer today, and he said those units come sealed to enable so no fumes come out. And they can be in a sleeping room. The code doesn't denote whether it can or cannot. But if that unit is broken, then it becomes a hazardous situation. But the units come sealed and then installed.
So the bathroom downstairs, there was a bathroom, I take it, that the sump serviced.
If you walk around to the outside, on the other side, there's a bathroom almost. If you walked through that wall, you'd come into a bathroom. So it services that bathroom and goes up because it's at the lowest point of the grade of the house,
Okay.
and then grinds the material, and then the material goes up to the sewer connection.
Okay.
Yes.
Yeah, and then I guess for legal counsel, just quickly, since we're looking at sort of words, applicant's counsel talked about it being prospective in nature, so that the is. I'm looking at the language of the settlement agreement, and I'm specifically looking at the release, and it talks about the project, and when it defines the project, it's referencing the city's approval of ordinance numbers 1622, 1623, and 1624. I don't see anything that talks about enforcement of those ordinances. Is there anywhere in this agreement that exempted the applicant from enforcement of building code or the STLU ordinances?
I'm going to answer that in two ways. First, when we were given the opportunity to review the settlement agreement, because my firm was not involved with it, we did a read of the settlement agreement, and our interpretation of the settlement agreement was that it did not include enforcement efforts. That's my first answer. My second answer would be that Best Budget Krieger did do an analysis of the settlement agreement at the time, and they also submitted their supplemental papers. So you could refer to those which are at attachment 7. Also, Scott Smith is here today, and he'd be happy to address the specific question for you.
And in any of the notices we gave the applicant, did we specify a time frame for compliance in terms of when they needed to comply by?
I do believe so. I'm going to double check. I think it's usually a 30-day compliance period, but we have those at exhibits.
No, so they are, but I guess in the letter, it's saying that we didn't issue a notice of correction at any time?
See, so if you look at our staff report on page 6, we discussed the reason why there was no need for a notice of correction, and that specifically is because these violations, particularly the ones relating to the uninhabitable room and the unpermitted wall, were serious, dangerous threats to health and safety, and in those situations, no notice of correction is required.
And those were serious threats because it was unpermitted, so the city never got a chance to look at the wall and make sure it was constructed appropriately.
Correct,
And
correct.
we didn't get to make sure that the electrical outlets were installed correctly. Is that correct?
Correct.
Do we know who installed the wall and the electrical outlets? Was
I
it the-
will defer to staff on that, but from my understanding and talking with staff and in reading the submissions and records that the staff has pulled for this property, the ownership has been consistent with the current owners, and at some point during their current owner's ownership, that's when this wall has appeared. But I'll let staff speak to that if I do not have that correct.
Do we know when the wall was built?
We don't have a specific date of when it was built. However, we do have information. A number of the homes on La Ventana were destroyed in a landslide years ago. The Shickleys owned the property when that occurred, and then we have the permits that they went through, the city and the Coastal Commission, to rebuild the property. I'm not. We can find a date of when those permits were pulled, sometime between their ownership when they rebuilt the house and December of 2017, the wall appeared.
Okay, and final question, sorry, and there's lots of lawyers here, Mr. Smith, one of you can tell me this. I asked the question earlier as to whether the city had the power through an agreement, through a release or otherwise, to basically exempt a property owner from complying with the municipal code. Can somebody answer that question?
Scott Smith, City Attorney. No, a settlement agreement could not forgive that violation of the code, especially as relating to future occupancy and future rentals. And just to elaborate on the letter that we submitted that was affirmed by the hearing officer, these were two different things. One was the release of claims arising in the original lawsuit against the city. They were raised under CEQA and the Coastal Act. Those are the ones that were settled and that the release is applied to. In the discussions, and as manifest in the agreement itself, was a separate ledger, let's say, of each property that was included. And I think a clear understanding, if you were there, that those ledgers were what they were, and that as they accumulated in violations, they would still be subject to revocation dating back to when those first occurred, as prescribed in the ordinance.
In other words, we would not have executed a settlement agreement that gave anyone a free walk to be able to have a structure that was unpermitted and unsafe.
No, we wouldn't even have authority to do that.
Any questions?
I have one question, if I may. Adam, may I ask you a question about the code in terms of this short-term lodging unit ordinance? Say if a owner of an STLU has their permit revoked is there any point in time in the future that they could operate again?
No. Once an owner has a permit revoked, they would not be able to get another STLU operating license.
Go ahead.
I can't make a motion before we close the public hearing.
No other input? Hearing's closed.
Okay, so I'm going to make a motion. Before I do that, I just want to commend staff on an excellent job, both contracted staff and personal staff. But I just need to address a couple comments that were made by Mr. Malamy. He likes to come in here on a multitude of issues and poke holes in everything the staff does when they're doing a fantastic job. And I just like to read in the record, which this was a multi-page document. And in the record, we have 9 phone calls and 15 email attempts over a period of 3 months for staff to reach out and reach across the aisle, as Brad had mentioned, was not done. So for the record, that has been done by staff. They did a fantastic job. And with that, I'll go ahead and read my recommendation. I move that we adopt Resolution 1901 entitled Resolution of the City Council of the City of San Clemente, California, affirming the revocation of short-term lodging unit STLU operating license 314901 related to the operation of STLU at 2813 La Ventana, San Clemente, California 92672.
Is there a second?
I'll second.
Okay, I have a motion and a second. Is there any additional discussion? All in favor?
Aye.
Any opposed? Motion carries 5-0.